Well, good evening from Sutkieweicz. Just turned 9 o'clock. Our clocks went back yesterday, so we're now an hour behind where we were yesterday. We all got an extra hour in bed, so that was good. And hi Jazz, hi Sean, hi Becca. A couple of things to mention. Obviously tomorrow, usual time of my 11 o'clock, which I think might be an hour later for the doctor. So we're waiting to see if that's okay with Dr. Siltman. I would imagine so. Not too sure about Millbilly. Depends if he's working, and if that hour later, if that just makes it a bit too late and past Millbilly's bedtime. Let's hope not, but fully understandable if so. Hi Mose, and also if Mark's available to join us, that would be good as well. But I know that myself and the good doctor have got loads to discuss with regard to the Mark Godsey book. Yes, free Brendan Bean is. I'll save that picture for tomorrow and show you all. I've already shared it with Millbilly and Becca here. Another thing I wanted to point out was yesterday I had a very pleasant exchange of emails with Bose12345, who is quite happy to come on and debate the case. As I say, we exchanged, pleasant enough emails, and I'm for example, I know that he was telling me that today he's busy helping his friend or neighbor who's he's got to help fix the guy's roof. We might have completely contrasting opinions, but we can still be pleasant enough to one another. And I was reminded of my I would say, about 5 months worth of phone calls and conversations with Sheriff Herman back in 2016. Always very pleasant. It was always nice to chat with him. On more than one occasion, he said, well, you're entitled to your opinion, I'm entitled to mine. And I must admit, back then I thought, well, your opinion, how can you not see? But the more you read things like the book Blind Injustice by Mark Godsey, you realize that there are people out there that genuinely do see things a different way. And they have their opinion. We've obviously got ours. We wait and see what happens. But I say I'm looking forward to hopefully being able to have a chat with Bose 12345. Hi, I see Dark Side of the Moon and Alice and Paul. Have I missed anybody? I don't think I've missed anybody. Yeah, no, I think everybody's there. Okay. So let's just crack on with the next part of the Kathleen Zellner's motion. Which is ready, lined up to go. Yep, everything seems to be working okay. We got as far as item C here yesterday. Item C, Steve's current claims are clearly stronger than prior post-conviction counsel's claims. Failure to hire experts. Prior post-conviction counsel ignored the ineffectiveness of trial defense counsel failing to retain experts. Clearly, prior post-conviction counsel recognized the need for experts on Mr. Avery's behalf because they asked the court for an extension to retain experts and stated as follows. Counsel would be remiss if they did not consult with scientific experts on matters beyond their own knowledge and expertise just as counsel would fail to satisfy their ethical obligations if they did not pursue potential leads for post-conviction relief. Despite the fact that prior post-conviction counsel recognised the need for experts, they failed to retain a single expert to review the key pieces of forensic evidence that resulted in Steve's conviction. Prior post-conviction counsel failed to detect the illegal seizure of groin swabs taken from Steve. Prior post-conviction counsel failed to retain their own experts in blood spatter, ballistics, DNA, anthropology with kerf mark specialization, forensic pathology, police procedure, and audio enhancement, who would have been able to demonstrate that all of the forensic evidence used to convict Steve was planted, as summarized at pages 99 for 103. Both trial defense counsel and prior post-conviction counsel were ineffective, pursuant to Strickland, in failing to hire the above-listed experts. Their deficient performance falls below an objective standard of reasonableness. Mr. Avery was prejudiced by their deficient performance. In State versus Thiel, finding ineffective assistance of counsel for the cumulative effect of their errors. The cumulative effect of trial defense and post-conviction counsel prejudiced Steve because both failed to review certain portions of discovery provided by the state, failed to master the discovery documents, failed to independently investigate certain lines of inquiry about Bobby and Ryan, and failed to initiate an investigation of any additional evidence or information to impeach them. In Thiel, the court instructed that in making a Strickland evaluation of prejudice, the totality of the representation standard is not the proper inquiry, but rather the effect of counsel's act of or omissions on the reliability of the trial's outcome. The cumulative effect of all of these deficiencies undermines confidence in the outcome of the trial and establishes Strickland prejudice. Even though prior counsel performed well on some aspects of the trial and post-conviction, it does not offset the cumulative effect of their deficiencies in failing to master the discovery, independently investigate third-party suspects, and obtain experts to undermine the very flawed theory used to convict Steve. And now I don't know about you, tell me what you think, but I was so naive when I was watching Making a Murderer. I didn't know how it ended when I watched it the first time. And I was waiting for somebody to come forward and to expose all of the lies and the corruption. And until it got to the 10th episode, and I'm thinking, when is this all going to get resolved? And it was towards the end that I realized this is horrendous. This isn't getting resolved. And of course, really, when you've got the state playing the kind of games in the case of Ghan and Fallon and Kratz, with the assistance of Judge Willis, when you've got them determined to convict Steve, no matter what the best efforts of Steve and Dean and Jerry were, they didn't have the funds to do the kind of investigation that Kathleen Zellner has. She's the one that's come forward and said, "Oh no, this is all completely junk." But as I say, when it happened at trial, no wonder people are getting wrongfully convicted left, right, and centre. When there's absolutely no one looking after their interests. Obviously, the state isn't going to. All they're interested is getting another conviction that makes them look good. Anyway, failure to raise ineffective claim regarding the impeachment of Bobby. Prior post-conviction counsel filed Steve's 97402 motion immediately after trial and were ineffective under Strickland because they confirmed their ineffective claim against Dean and Jerry and Dean to the narrow issue of juror removal. They overlooked the clearly stronger ineffectiveness claim of trial defense counsel's failure to impeach the state's primary witness, Bobby, and other witnesses, and to hire vitally important experts to dispute the state's experts. And I'll say it's they really didn't have the opportunity to do any of this, though, did they? There's not a limitless amount of funds, or certainly the funds that Kathleen Zellner can put into this. And I hope she is very, very well rewarded for all of her efforts. Anyway, the court in Rather versus Meisner, 7th Circuit 2015, reversed the Wisconsin state court decision for applying the wrong standard in Strickland. The Rather court noted that Strickland is the benchmark decision for claims of ineffectiveness and provides that the Sixth Amendment's guarantee of the assistance of counsel is violated if an attorney's actions are objectively unreasonable and prejudice the defendant. The Rather court stated, although the court identified Strickland as the controlling legal authority, it did not apply Strickland's framework. Rather, in assessing whether Rather was prejudiced by counsel's errors, the court required a showing of but-for causation. That is not the standard. Instead, a petitioner must demonstrate a reasonability. I'll get there in the end. Reasonability, probability. Easy for you to say. Defined as one sufficient to undermine confidence in the outcome. That counsel's errors materially affected the outcome of the proceedings. Strickland. In this battle of credibility, counsel's failure to make use of the witness's prior statements doomed Rather's prospects from the beginning. Had counsel cross-examined the witnesses adequately, he would have cast significant doubt on Danielle's and Bragg's testimony, which was ripe for impeaching. A ripe peach. Prior post-conviction counsel failed to recognize the Strickland ineffective argument that should have been raised about trial defense counsel's failure to recognize the significance of Bobby's statements, of Brian's statements to the police, and that Brian could have been called to impeach Bobby. On the pivotal issue in the case, did Teresa leave the Avery property? Nearly 15 years ago. See Washington versus Smith, finding deficient performance where trial counsel failed to investigate and call significant witnesses. Post-conviction counsel failed to raise the clearly stronger Strickland argument regarding the failure of trial defense counsel to impeach Bobby. Steinkeller, I presume, and Meshner. The ineffectiveness of prior post-conviction counsel is a sufficient reason to overcome the procedural bar relied upon by the circuit court in denying Steve's relief on his current post-conviction motion. These failures, combined and individually, constitute textbook deficient performance. Strickland at 691. Counsel has a duty to make reasonable investigations or to make a reasonable decision that makes particular investigations unnecessary. Jenkins, finding deficient performance of trial counsel for failure to call a key witness. The defendant must show that counsel's failure resulted in prejudice. In order to demonstrate prejudice, Steve must show a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. Again, Strickland 694, a reasonable probability is a probability sufficient to undermine confidence in the outcome. When a defendant alleges multiple deficiencies by trial counsel, prejudice should be assessed based on the cumulative effect of counsel's deficiencies in Thiel. To be clear, prejudice is not an outcome determinative standard. The focus is on the reliability of the proceedings. So we've got a quote here from either State versus Peach or State versus Smith. The result of a proceeding can be rendered unreliable and hence the proceeding itself unfair, even if the errors of counsel cannot be shown by a preponderance of the evidence to have determined the outcome. So in Peach, here, prior counsel's deficiency has rendered Steve's trial unreliable. The sole issues at trial were the forensic evidence linking Steve to the victim and the identity of the murderer. Trial defense counsel presented no real defense to the state's forensic evidence. Trial defense counsel called 7 witnesses, only 2 experts. Steve did not testify. Yeah, that's always a bugbear, isn't it? You know, it's, you know, when Brendan was allowed to testify, he was just being honest. When he didn't know the answer, he didn't know the answer. When he did, he did. You know, and he wasn't there to show off or to give a great speech. I must admit that's one of the bugbears, isn't it? Because it's always something that'll be hurled back at Steve. You know, what were you trying to hide by not taking to the stand? I know it shouldn't. I know the rules are there to say that, you know, that shouldn't have a bearing, but it does. It affects the, you know, perception of people. I think anyway. So Mr. Avery did not testify. The jury was left only with the state's unrebutted forensic evidence and the undisputed testimony of Bobby that Teresa walked to Steve's trailer and was never seen again. All of the evidence incorporated in the Allen chart on page 99 to 103 applies to prior post-conviction counsel's ineffectiveness in conducting a significant investigation to impeach Bobby and others, and in failing to retain experts. The above listed claims are obviously stronger than the claims raised by prior post-conviction counsel. State versus Ballett, regarding a defendant's ineffective assistance claims where the defendant did not assert that the claims counsel failed to raise were obvious and very strong. No. Angela, the circuit court abused its discretion in dismissing Steve's second motion pursuant to Wisconsin Statute 97406 without requiring the state to respond or conduct an evidentiary hearing. A. Standard of review. The Wisconsin Supreme Court has ruled that a trial court may deny a motion for post-conviction relief under 97406 statutes without a hearing if the motion fails to allege sufficient facts to raise a question of fact or presents only conclusory allegations, or if the motion, files, and record conclusively show that the defendant is entitled to no relief. Whether a defendant's post-conviction motion alleges sufficient facts to entitle the defendant to a hearing is a mixed standard of review. First, the appellate court determines whether the motion on its face alleges sufficient material facts that, if true, would entitle the defendant to relief. If the motion raises such facts, the circuit court must hold a hearing. This threshold inquiry is thus a question of law subject to de novo review. A circuit court's discretionary decisions are reviewed under the deferential erroneous exercise of discretion standard, State versus Bentley. As with any other civil pleading, in assessing the legal sufficiency of the motion, the court must assume the facts alleged therein to be true. Grichner versus Michael. Even if a court is disinclined to believe evidence offered by a movement, the court must hold a hearing before making credibility determinations. State versus Allen. State versus Leitner. Holding that when credibility is an issue, it is best resolved by live testimony. Only after a hearing is the court charged with determining the issues and making findings of fact and conclusions of law. Wisconsin Statute 97406 3D. Enroll. The defendant filed a motion for post-conviction relief. The circuit court denied the motion and the defendant appealed. The Court of Appeals reversed and the state petitioned for review. The Wisconsin Supreme Court held that while the allegations in the petition were initially conclusory, the circuit court had permitted the defendant to supplement his allegations with an affidavit. Because the affidavit provided some support for the conclusory allegation, the Wisconsin Supreme Court held that the circuit court abused its discretion in dismissing the petition without an evidentiary hearing. In Zoll versus State, the Wisconsin Supreme Court held that the circuit court abused its discretion because the motion set forth sufficient factual allegations such that it should not have been summarily dismissed. Defendant's only support for his allegations was his own affidavit. The circuit court dismissed the motion, finding that the defendant's allegations was not supported by the previous trial court record. The Wisconsin Supreme Court explained, "This is not the test. A silent record does not conclusively show that the defendant is entitled to no relief. The defendant's burden at the first stage of the act is to present an issue of fact that, if later proven at a hearing, would entitle him to relief." The court in Allen determined that a motion contains sufficient material facts for an evidentiary hearing if it includes the name of the witness, the who, the reason the witness is important, why and how, and facts that can be proven, what, where, when, that clearly satisfy the Bentley standard and would entitle a defendant to a hearing. As the chart illustrates, Mr. Avery has met all of the requirements of Allen. I think that's an absolutely perfect place to stop for now. As I say, I don't want to keep you too long with these. So we look forward to looking at this particular chart. Yeah, let's come on out of that. So yeah, that's another quite a big chunk of testimony there, of motion outside there. Another thought that always crosses my mind is, when you've got somebody of the expertise and the knowledge and the skill, who's who knows what she's talking about. She's got she's got the T-shirt. It's a bit unfair to obviously at times to compare other attorneys with what Kathleen is able to do. Not just the fact that she brings her own investment into the case, but also what price her knowledge, as I say, knowledge, expertise, and the fact that she can call on these experts, who are the leaders in their field. It's very, very impressive, very, very impressive indeed. So anyway, just to recap, so tomorrow morning, my time, 11 o'clock, which I think will be around about 8:30 for the doctor. So hopefully that won't be a problem for him. I'm hoping it's not going to be a problem for Millbilly if he's around, but it does mean I think it's going to be an hour later than it was the last couple of weeks. And if Mark's able to join, all well and good. We've got plenty to look at, particularly, as I say, with the book Blind Injustice. And who knows? As I say, I've made contact with the guilter, Bose 1 2 3 4 5. We've exchanged some emails, and we look forward to possibly having him come on and give the other side of the point of view. That'll be interesting. I think it's fair enough that there is this other point of view. Anyway, we'll wait and see what happens. I can't say any more than that. Obviously, we need to get that arranged, and it might not be until after the end of the month. But no, what I'm certainly hoping to do at first is just to do a sort of conference call with him to to see what how we're going to do the debate as it were. He's suggesting the Lincoln Douglas type debate, and I'm saying, well, no, I'm quite happy for you to do most of the talking and then just answer questions at the end. Give the guy a fair crack at it, and just try and make it as classy as possible. Anyway, look, we'll cross that bridge when we get to it, and hopefully it'll come to fruition. I'm certainly a lot further forward in a few days with Bose than I have been in about a year and a half with trying to get cartoon character to come on debate. And he or she just keeps posting stuff. I keep deleting it without even reading it. I've made it clear what needs to happen. Clearly, it doesn't matter how many times I tell this individual, they're not listening. Oh well. If you want to waste, what's clearly sometimes quite a bit of time typing in all that you've typed in, just for me to come along, not even read it and delete it. If you think that's sensible on your behalf, fine. But you know what the answer is. Accept the invitation. Come and debate it. We can be very polite. You certainly haven't been polite on many an occasion. So just change your tune. As I say, I suspect you're just a bit of a coward. You don't fancy the idea of having to try and explain, because certainly I've got questions. I've got questions about this case. As I've said all along, as I said to Sheriff Herman when I first spoke to him, if we're all wrong, if we've all got it wrong, and we were all duped by a documentary, as you keep saying that we are, if Kathleen Zellner, after she's conducted all her investigations and tested all the evidence, if the evidence comes back and says, here's something we missed, That makes all the difference. That proves that Steve's guilty. I'll be the first on the phone to apologise. At that time, it was Herman. I would happily get on the phone and apologise to Weigert and Dan Hartwig, who's the current sheriff. But if we're right, if Steve and Brendan were framed and they're innocent, what should happen? What should happen to the bad actors involved in this case? Anyway, I'm going to leave it there. I'll say we'll catch you all soon. Take care. Bye for now.